to the Level Up Artist Podcast. We're your hosts, Adriana Amay and
Jackie Sanders. We are two art professionals sharing for the advice and business lessons we have learned along our creative journeys.
we talk to artists, leaders, and art professionals to demystify the creative process and discover new ways to succeed as a career-minded artist.
If you find value in these conversations, please go ahead and subscribe. This will help other creatives like you find our podcast, and you'll be notified when we drop a new episode every Tuesday. On today's episode, we're going to be covering a very important topic for any artist, especially career-minded artists, which is image copyrights. Now, big disclaimer right at the top, we are not lawyers. So if you are seeking legal business advice or think you may have a case where someone is trying to steal your artwork copyright, please contact a professional. However, today we are going to get the topic started as just that base layer in case you've heard the term thrown around, but you're not quite sure what it means for you and your artwork. That's what we're going to cover today. We're going to cover what an image copyright is, why is it important to keep it as an artist, how do you get an image copyright, and then factors to consider when display opportunities, contract, or sales involve that copyright verbiage. Because oftentimes as artists, you can read over that and say, I don't really know what this means. We'll just hope for the best. We're not going to do that anymore. We're going to go over some of the terms that you can keep out for to protect yourself. But first, to keep it super simple, Adriana, what is an image copyright?
Yeah, absolutely. So, one other note with that too is to say, depending where you're listening to this, we're going to take the approach, and the research that we did is based on US laws. It's a little bit different for other countries, so make sure you double check, fact check the information we're giving you. But essentially, the image copyright is the legal right granted to the creator of the original artwork. So it gives you exclusive control over the use, reproduction, and distribution of the work. And in the States, you automatically, as the artist, as long as this is not derivative, which is another bag of chips, but as long as it's your original creation, you automatically have the rights to that image and to decide what gets done with that image, right? Nobody else gets to do that for you. Um, I believe it's a little bit different, and we might dive into this later. If you are working for a company and you are on their payroll to create art for them, that might be different. But if this is something you created in your house, in your studio, for yourself, for your own art business, technically that artwork is already copyrighted as yours, right? Or considered to be your right. And in terms of like protection of the creative work, maintaining copyright essentially ensures that you as an artist can protect your creative work from unauthorized use, and this is going to be crucial for safeguarding the integrity of the artwork and make sure that the artist's vision and intent is preserved. So we're going to go a little bit deeper into this, but essentially like that image copyright is supposed to be protection, and it's supposed to a way to say, look, so and so made this artwork, it belongs to them. Joe Schmuck living down the street, you do not have a right to reproduce this artist's work without their permission, and possibly without compensating them first. You can't just rip off somebody else's artwork and pass it as your own. So that's where some of the stuff we're going to be unpacking, that's where it comes from.
Yeah, exactly. And that's actually one of the key factors as to why it is super important to keep your copyright as an artist. There's a couple of different main reasons that people think about. The first one, of course, being the financial benefits. By keeping those rights, you as the artist can monetize your work through channels such as selling prints of your work, licensing that image to larger commercial use, or creating derivatives of that work, different iterations. So even if you've sold, for example, the original painting, you still have the right to sell art prints at future markets or at your studio or on your online shop because you hold the right to that artwork. That did not leave your studio with the original painting when you sold it, unless you have in the contracts as so that we'll go into later. Because that can be a huge income stream for many artists. We have a lot of episodes talking about that to where you can have one painting, not just be that original sale, but also can become future income streams by making art products. So huge financial benefit by having that copyright. The second one, thinking about your control over reproduction and distribution. Similar to art products, but you have control over when the artwork is reproduced, how it is. And as an artist, especially thinking about the larger brand that you're building, you don't necessarily want low quality prints out there in the world thinking that they came from you. You want to have control over where your artwork is seen, how it is presented, and to keep that control in your hands is really the only way you can do that. And of course, that also comes down to why it's important to keep the copyright as an artist, being the legal ramifications of it and having that infringement. So if someone else uses your artwork without your permission, you have the rights and have that legal framework to take action against them for that action. So someone can't come to an art market, take a picture of your painting, and then start selling it themselves, right? This could, of course, can include seeking damages, financial compensation for if someone sells your work, and a whole bunch of other legal ramifications that can feel a little intimidating. But it ultimately starts with you want to protect your creative property. You want to protect where your artwork is seen, how it is presented, how it is experienced. And it starts with keeping that legal copyright of your artwork.
Yeah, absolutely. And with that, you might be thinking like, but do I have to register it? And look, it depends. Like this episode, we're specifically talking about copyright and quick parentheses I want to make. This is different from patents and trademarks. Sometimes they get lumped together in conversation, and some of the other ones you actually have to apply for. You basically say, this is what I created and I have to go through a legal process or at least an approval process to say, I invented this thing, which depending what medium as a creative you're in, you might have invented a thing, right? Then you have to go through the patent office. Or I created this very specific name for my brand. I have to go through the trademark, office and things like that. But as a creator of original artwork, at least in most countries that we've researched, it's automatic. So the moment that you create the thing, your copyright is fixed, right? It's already tied to the work. You are the creator of the thing, right? And while copyright is automatically granted, kind of like touching on something that Jackie just said, it is essential that you document at least some parts of the creation of your work, even if you don't necessarily share it online, but definitely track some of the stuff, high resolution photographs, sketches, drafts, anything where you're tracking the documentation, because what could happen and has happened, and you can Google this up and it will come up, you will have, and we're not even going to unpack AI right now, but there are folks that unfortunately don't have great intentions. Let's go with that. And you come up with something really cool. I don't know. You made a sticker of a cat on a skateboard. I don't know, making this up. And it gains traction. It gets viral and everything else. You're going to have copycats trying to do exactly the same thing. And do you think they're going to pay you? They're not. They're going to keep all the money from your original creation. But if you were like, wait a minute, you have what's one of the companies that gets in trouble a lot? Anyways, there's several. Let's say it was Target. Let's make this up for a second. Let's say that one of the creators at Target, because I feel like at this point, let's add an example. Let's say that one of the creators at Target, one of the brands where they're working with other creatives, essentially rips off your cat on a skateboard idea, right? Then you can go to Target and say, hey, so this is awkward, but I came up this image that now you're selling on towels and you're selling it on phone cases and you're selling it on the stuff under this brand of this other creative. I actually have proof that what you're selling is essentially a copy of something I created 5 years ago. And here's all the proof behind it. And you can kind of start going that route. But if you're like, no, I came up with it and you have no proof, your case is kind of weak sauce, right? Because they're going to go, how do I know that you didn't copy it from this person that we signed a contract with that says they created it? So that's the kind of thing where you're definitely going to want to document some of the stuff. Again, whether you share it online or not, but if it goes to, court, if you're going to be using a lawyer, they're going to ask you, where's the proof that this is yours, that you created it, and that you didn't copy it from somebody else, right? So, anyways, there's a lot that goes behind it, but documentation, folks, it's key. Again, whether you share it or not, you definitely want to document.
Yeah, and as Adriana mentioned, there is an option to register your trademark or copyright. Obviously, that can be a little bit overkill. You definitely want to do that with the name of your company, or especially if you're looking to build out a larger, let's say, product line that you're looking to have in stores, that you're looking to scale to become larger. That would be a great thing to do during your journey, but definitely consult a legal professional with those. And especially in the beginning, up front, when you're just starting off, it's probably overkill. But if you are really looking to establish that brand, it's a great thing to keep in mind for down the road.
Yeah, and before you register for any of the stuff, definitely make sure you research it thoroughly. Otherwise, you're going to pay for fees to copyright, trademark, patent, depending which one you're doing. And it may come back and they might deny you and say, actually, somebody already did this like years ago, like you're late to that party. If it's too close, they're going to say no, but you already paid. So, anyways, do your research before then. Most everybody, like Jackie said, overkill. Most of us don't need it, again, unless we're going to go giant brands, giant agencies, that's another bag of chips. So food for thought. Another great thing about copyright, again, at least in the US, is you don't have to be an expert in all this. You just mostly need to be aware of this information we're sharing so that you can see it when it comes up in contracts and keep an eye out for you, depending who you're working with, whether it's like a licensing company or a gallery or a nonprofit, right? Or again, you are a worker for hire, then it's important to know then in the contract, how are they treating that artwork? And are they asking for rights in perpetuity to continue to reproduce the work without necessarily even mentioning your name? So these are like some of the things you gotta look out for, even if you don't know copyright legalese that might be in a contract. But it could definitely be something that you kind of like flag and go, oh, wait, this sounds a little off. So instead of skimming through that, actually do read through that in your contracts if you're getting one. And if not, you should consider having your own contract if they're not giving you one, especially in cases where there might be a product involved. So next up, we're gonna deep dive a little bit more and continue to talk about factors to consider when seeking display opportunities. We'll talk a little bit more about contracts and different kind of sales that may involve copyright verbiage. But first, let's take a quick word from our sponsors.
This episode is brought to you by our Level Up Artist courses.
We understand that life as a modern artist can be both exciting and overwhelming. Plus, there's a lot of information out there. So what do visual artists actually need?
We've spent countless hours of trial and error, weeding through tons of information to find the gold, so you don't have to waste your time going down those endless rabbit holes.
In addition to weekly calls, we have created video course modules to cover everything from artist documents to exhibition prep, social media to technology, sales strategies, artist mindset, PDF resources, templates, and so much more.
Ready to get started? Head on over to levelupartists.com to learn more, get immediate access, and level up your career today. Welcome back, everyone. So if you make a painting and it stays in your home, you rarely have an issue with copyright infringement, obviously. But it is something that you have to be more and more aware of as you move forward with leveling up your career, seeking display opportunities, and making sales as an artist. So most commonly, you'll want to keep an eye out for verbiage that involves these copyright ideas, mainly when applying for open calls, when applying for art display opportunities at galleries, community centers, or businesses, or signing or creating contracts for those individual sales and commission projects. So, Adriana, what is some of that verbiage that people will want to look out for during these scenarios?
Yeah, so some of the ones that we've seen and found in our research as well, one of them, this one kind of scares me a little bit, is full transfer of copyright, which you can see that in a contract. It'll say, a clause, something along the lines of the artist hereby transfer all copyrights and intellectual property rights to, fill in the blank. Um, Again, if you're doing this as in they paid you to create the artwork, that's different. Like commission artwork for, let's say you help them create a logo, right, for a business owner. That's a little bit different. That's like work for hire. But if it's artwork you created all on your own, not a commission of any sort, like not working, for a creative employer of any sort, and you have somewhere where you're going to display your work and they're asking you to transfer all your rights, run, run, and or have them revise it. You can question it because also it could be that they used a template that they copy pasted from somewhere on the internet and didn't realize that was there. Give them the benefit of the doubt. Doesn't mean they're evil trying to steal your stuff, but definitely question it if you see full transfer of copyrights in any way, shape, or form. Again, work for hire, different. It's very different. Depending what kind of arrangement you do, just because it's work for hire, don't assume that the rights automatically belong to them. They might just say it might be something along the lines of like, okay, we hired you to create this work for us. You're giving up the right to reproduce it, for example, right? You just made something for a brand. You may not reproduce it and sell stickers of their brand without them knowing about it, like, not cool, but it doesn't necessarily mean that they can't credit you. So that's something you're going to have to work out because you might be like, cool, I'll make you this brand logo, whatever, and you guys are going to make stickers. Can you at least credit me and say artwork by? Right? It's still their brand, it's still their thing, but maybe there's a way that your name can be in there. So don't discard it right away just because it's for hire. You may still have a way of getting credit somehow. It just might mean that because they paid you for it, you don't get to make money off of it. So definitely something to look out for.
Yeah, another thing to look out for too is kind of the middle ground there, saying that the institution has quote unquote exclusive rights. So something along the lines of the gallery, for example, will hold exclusive rights to reproduce, distribute, and sell artwork. This definitely suggests that the artist no longer retains those rights. So that can be a little bit of that gray area. Of course, if they say there's a full transfer for copyright, that's a huge red flag that you no longer have the right for it. If it says work for hire, you have to be a little bit more detailed with what those terms are. But it says exclusive rights. That's another situation where you're going to want to dig a bit deeper of what is exactly meant by that. Based off the phrasing, it may imply that the artist no longer has those rights, but you want to clarify that, especially in things of establishing, okay, for how long, especially if it's a group exhibition, for example. Okay, do you have exclusive rights just while you have the artwork on display? Do you have exclusive rights for a year? What is that and what does it entail? Something else to really, that's a obvious red flag to make note of is if you see the term ownership transferred, kind of similar to full transfer of copyright, but it may show up in statements such as ownership of artwork, including all copyrights, is transferred to the gallery, community space, whichever, upon sale and display. So that's a pretty clear indicator that you as the artist are not gonna have rights to your artwork anymore, which is actually a big reason why I brought up doing this topic in general, because I actually recently went through an application project and I saw this at the very end of terms. It was an open call to where I had already written my bio, written my statement of interest, uploaded pictures, got them all formatted, frankly, spent a good amount of time. And it was in a form where you are online, you toggle through all the different pages, upload your assets. And on that last page, right before the finish button, in text that's buried in a paragraph that I probably realistically might not always read, even though I should. I saw that the phrasing that ownership of artwork, including copyrights, is transferred to the gallery upon display. And so even, for example, this opportunity was a paid experience. They were going to be on display for 1 year. You would get a financial stipend, which would be amazing to have that on display. But I realized that even if they paid me to have artwork on display there, the amount of potential loss that I would have by not being able to sell any prints of that artwork in my studio would not make sense for a full year. So to put a little bit in context, for the anonymity of this institution, and it's not a display opportunity that's any longer available, but let's say, for example, they paid like $250 for the opportunity, right? Okay, well, in 1 year of showcasing one of the paintings, which it was multiple paintings, if I'm selling prints at $45 a piece, that means, let's say if I make 6, 7, 8 sales of one of those prints over a year, so one every other month, I'm already making more money than this opportunity would get me. Which, of course, caveat of you get in front of more people, different display opportunities had different benefits. There's a lot of factors aside from finances as to why you may want to display or get in front of a specific group. But this was an opportunity where I realized, okay, it was the day before the application was due. So I really did not have time to email them or call them to ask about specifics, which is another reason to do applications in as far in advance as possible. If I had another week, maybe I would have pushed them on it. I may have kind of asked questions of, did you know that this is what this meant? Because to Adriana's point, sometimes institutions or smaller organizations just find a contract online. They say, yep, sounds good. And they don't necessarily even have bad intentions with trying to scam the artist. They say, oh, we just want to take pictures of the exhibition and put it on our website. And so we just figure we have to have rights to it, which like that would be great. But it was a situation where at the end of it, even though I had already spent time on the application, I realized that it didn't make sense for me to risk losing copyright to multiple of my pieces, which really is a shame, but brings up great conversations like this and really thinking about how important that is.
Yeah, yeah, I recently saw a mural application like that. And it was like at the end of it, it was for a city. At the end of it, they retain the rights to like reproduce it. So it's like, you know how a lot of us do like digital mock-ups and things like that? It wasn't just photos of the mural itself. It was like they wanted ownership over the serious mock-up, if you will, of the design. And they could put it on t-shirts and postcards and billboards and all those things to promote their city without paying you anything extra. And that's where we're like, I don't think so. Like, you want exclusive rights? Like, I won't transfer the ownership, but if you want rights to reproduce the work, you're paying extra. That's not included in me like selling or making this for you. So
Yeah.
definitely keep an eye out for those terms. And then there are other terms that are pretty direct, but also could be confusing. So we're continuing to unpack some of these for you guys. Another one that comes up, it'll say license with full control. So it'll say things like the gallery or the space is granted a license with full control over reproduction and distribution, which may seem like the artist retains some rights, but full control may imply a near total transfer of anything that's practical. So definitely something you want to talk to them about and be like, are you talking about you retain rights to reproduce on fancy schmancy full rag paper, but I can still do stickers of it? Like, like we need to draw the line in the sand of what this means. So you definitely want to ask about that. There's others that come up. Oof, these come up a lot. Exclusive display and reproduction rights. So sometimes you might think, oh, it just sounds like while they have it up. Not necessarily. Sometimes they're talking about not just like display in a physical space. It could also mean your own website, and they'll say you can't even show it on your website. It can also mean like you can't do prints of it. You can't have basically you can't not even in person. You can't even do stickers of it. Some of them it might be like sure, like it's limited amount of time that we have it, but it could also even mean only we can do it and only through our third party that we use, company, whatever. Like if you want prints of it, we have a company or they do it in house. It has to be through us. So definitely keep an eye out for them because you want the choice to change, for example, who you print through. But if you're signing that off away, then you may only be able to get it through that company. Like that, yeah. Yeah. Keep an eye out for exclusive display and reproduction rights.
Yeah, another term that honestly can get a lot of people sometimes in terms of like not sure, like, is this protecting me or should I raise a flag to this? Is when there's a term or a phrase that says the rights to market and promote. Because while marketing and promotion is a huge part of displaying artwork, and it might sound kind of benign, like oh, that's just a standard thing that they do, totally fine. If the contract includes things like the right to reproduce and distribute for marketing purposes, this could be a way to take some control over the artwork's use. Again, oftentimes, assuming people have great intentions, they just want to put a picture of the display in their annual brochure that talks about the community center, right? Or they want to be able to put it on their website. So this is not a huge flag right off the bat, but it can never hurt to ask, okay, well, what are the intentions with marketing and promoting it? Because if someone didn't have good intentions, they could say, oh, well, I'm printing this on t-shirts and that's promoting this event. Well, okay, if you're then selling those t-shirts, isn't that kind of borderline licensing? Like they can make a case that maybe that's just marketing and promotion. So there can be ways that can be more of a muddy gray area that you want to avoid. Another term that can sound pretty simple, but as a big thing to look for is the term in perpetuity. So if a licensing or rights grant is quote unquote in perpetuity, that means forever. Even if it sounds like a simple display agreement, those perpetual rights mean that the artist permanently loses control over that artwork. So anything that says in perpetuity, unless it's an exchange where you are selling an original painting to a collector or to a business and you are granting them the copyright transfer, which they should be paying additional money for, that's the only time you would ever want to do something in perpetuity. And the last one to really look at would be something that says all media rights. So this can appear in phrases such as the gallery is granted all media rights, meaning that this can be a very broad application because in this day and age, what counts as media? Is that print media? Is that digital media? But it does imply that future control over really any medium. So it's again, it's intentionally broad in general terminology to that it gives a lot of gray area for people with bad intentions to override and come in on your copyright, which we're trying to avoid.
Yeah, and also like with these things that we're talking about, just because you signed it doesn't mean it's legally binding. I mean, technically contracts are, but if the terms that they made you sign to are actually illegal, you still have some protections. It's just going to make it harder and probably more expensive to go through. But if they're asking you for something that's not legal, it's a lot harder to prove, right? That did you do it? Did they like trick you or not trick you? Did you know what it meant? Did you research it? So this is why like we're telling you what some of these flags are. Again, it doesn't necessarily mean, especially these last ones that we mentioned, that they're bad. Like I've seen rights to reproduce and distribute for educational purposes. I've even seen they are for marketing, but it's like a city and they're like, we just want to be able to put it on our website. Like, and it literally said it's for marketing, but we will not create any products or anything that involves income. Like there's no money involved. They want to promote you, they want to promote the artwork you did, but they're not necessarily selling stuff and they're not making money off of it per se, not in a direct merchandise type way. So do keep an eye out because then sometimes there'll be exceptions even when these are used. But definitely yeah. So a couple of things. Yes, these terms can be scary and intimidating. Definitely Google any terms that you're not familiar with. Thesaurus is your friend as well. If you know any lawyers, friends, or family, they can definitely help you with like learning what some of these terms are. But putting your business owner hat for a minute, there are some action-oriented tips that we want to share with you that hopefully will make this a little less scary. So diving in, the first one, the most obvious one. Guys, seek legal advice. Like, internet rabbit holes will only take you so far. It'll be good, obviously, for, Googling some of the stuff. But if you're like, this is a really big deal, there's a lot of money involved, and I am not sure, consult an attorney. Legal professionals the way to go to help you identify and explain any clauses that may affect your copyright. I have heard of this before. I haven't used them before, but I've heard of this before. And I've met some lawyers that do this, but I have not asked them if I have permission to share their info on the podcast. So you're going to have to do your own research. But I have heard of artists that will help creatives pro bono. Will help artists with questions if it's just simple questions. You don't necessarily have to pay. They're very well deserved, but could be a little outside of our budget fees for consultations. So some of them actually help artists and you can ask them questions. So definitely research that in your area. But if you're in doubt, the bigger the deal, the more likely you're going to want to spend that little bit of extra money on a reputable lawyer, especially if it's one that already deals with copyright and or is one that is already focused on artists. Your divorce lawyer friend that your grandma lives next to may not be able to help you with copyright specific stuff. So definitely try to find the right person for the job, but they are out there.
Yeah, absolutely. And if there are larger artists that you know in your area or on social media, especially ones that do large projects such as murals or large licensing deals, feel free to ask them who they use, especially in the digital age where you can meet with someone virtually. They may be able to answer a lot of your questions, whether pro bono or even for a hourly rate. You can ask them questions for 30 minutes or so. So feel free to lean on other artists too, because I'm sure they took a lot of time to vet out who they were looking for. But one thing to also think of, a more actionable tip if you're applying for opportunities or seeking out open calls, is just to make sure that all of the terms are clearly defined. So in the contract and the application, especially regarding those rights, reproduction rights, and distribution, because any ambiguous language can be interpreted against your interest. Of course, we hope that no one has poor intentions, but a great thing to do is, especially if it's a reoccurring event, if it's a space that displays artwork for artists frequently, you can look at their social media. You can go to their physical space and see how have they marketed these events before? What have they done after the event? And that way you can see, okay, this terminology more than likely simply means that they want to make brochures and pamphlets and post on social media because they've done this maybe art festival 5 years in a row, and I've never seen them reproduce the artist's work on t-shirts that they want to sell, right? You can use those context clues to infer, to give them the benefit of the doubt. But really, whenever you're in doubt, you can also ask them. Which is a big tip for especially applications. This is why it's especially important to be proactive, try not to procrastinate. So that way, if you see any verbiage, you can reach out to them through email, through a phone call, and clear up some of those unclear terms in the agreement so you have that time to reach out. And that's one thing I have done with previous opportunities as well, to where it seemed like they had really great intentions, what they told me verbally, and basically I mentioned on the phone with them. So, okay, that sounds wonderful. If I'm chosen for this opportunity, I'd love to have those terms just fleshed out a little bit more in writing to decide what you get access to and what I do. And they said, okay, yeah, that's totally fine. Turned out not being an opportunity that I ultimately was a good fit for, but that was a big comforting factor in when I was applying for it. Which brings me to the next tip of being able to negotiate those terms. So don't be afraid to negotiate terms that protect your rights. Of course, an organization or an event has every right to say, nope, these are our terms and you have to agree to it or not. That's totally up to them. But especially if you're being commissioned for a project, if you want to sell artwork directly to a collector, you can be in control of where your art goes, who it goes to, and how it's used. So you want to ensure that any licensing grants are non-exclusive, or if they are exclusive, define what that time period is for, and just really clearly define what that scope of work is. So that way it just keeps you in control and saying, okay, you as this organization have right to reproduce the work, but only for 6 months and for this additional fee. After 6 months, I retain rights again. Things like that, that really just put you in control of where your artwork goes.
Yeah. And, retention of copyright is definitely something that you want to insist upon. I've even seen contracts that talk nothing. Literally, all these words that we mentioned, they are all missing from the contract. It says nothing about the rights of the artist, copyright, reproduction, distribution. There is nothing on it for whatever reason. Whatever template they grabbed off the internet did not have it. Or maybe they did it through ChatGPT, not judging, but definitely make sure when you look at that contract that there is language in there that talks about you retaining the copyright of your artwork. If it's not there, insist it gets added. Agree on the terms ahead of time if they want to do reproductions, if they want to make merchandise out of it or licensing or whatever. Definitely make sure. I've seen other artists get burned in the bum behind where either there was no contract or there was no mention of this or there is no paper trail of this. And then later on, the person that purchased the artwork made products out of it and gave zero to that artist, and they found out later. So protect yourself. Definitely have this in writing. Definitely have this, preferably with signatures. Old school, I know. Whether they're digital or not, but definitely signatures. So as we wrap up, we do know, obviously, we acknowledge it's taken us years to learn what some of this legal verbiage has been, and it may take time at first if you're not coming from a corporate or a legal background to be like, I just want to make art, like why do I have to learn all this stuff? But do know it's okay to question the stuff, right? And just protect yourself. Again, make sure there's a paper trail of all that kind before you sign on anything or hit that submit button on that application website. Definitely read the fine print.
Yeah, and with that also, hopefully, just with today's episode, being aware of a few of those terms to look out for, or at least have a yellow or red flag that comes up when you're reading through these terms, you'll have another tool in your tool belt to be able to move forward confidently, knowing that opportunities that you are seeking are with terms that you agree to.
Absolutely. Well, with that, we're going to go ahead and wrap up, and we hope you got a lot out of this episode.
As always, our notes will be linked in today's show notes where you can find episode notes and links to all of our other podcast episodes.
If you want to stay connected with us in between episodes, share your feedback, or have a question you would like for us to answer on the podcast, you can reach us through social media. I'm at May Art across all platforms.
And I'm at J Sanders Studio across all platforms. And if you want to follow the podcast, we are at Level Up Artists on Instagram.
You can also visit levelupartist.com to get immediate access to templates, resources, and course modules to level up your creative career today.
Thank you so much for listening. We'll talk to you next week.